For this panel, we have three distinguished speakers. Our first speaker is our own Professor Barbara Black. Professor Black will talk to us about the DC Circuit's recent decision in Business Roundtable versus the SEC and its impact on investor protection reforms as authorized by Dodd-Frank. Our second speaker is Professor Joan Heminway of the University of Tennessee College of Law. Professor Heminway will talk to us about the reforms to the institutional structure of the SEC that are required by Dodd-Frank. And our third speaker is Professor Eric Penn. Professor Penn holds an appointment at the Cardozo School of Law, Yeshiva University, but Professor Penn is currently on leave from his academic appointment and is now serving as the Associate Director of the SEC's International Affairs Office. Professor Penn will talk to us about some of the challenging issues in the cooperation among regulators of the world's major financial markets. And with that, I will turn the podium to Professor Black.
Thank you, Lynn. All right, so, you know, as many people have said today, it takes a crash, right? It takes a crash to bring about financial reform. That's not probably the optimal way to reform your financial system, but that's the way we always do it, going back to the 1930s and going through Sarbanes-Oxley and, of course, Dodd-Frank today. So it takes a crash to bring about financial reform, and after the legislation is enacted and implementation begins, the industry can regroup and focus on deregulatory efforts. And so so we now have cause even for repeal of Dodd-Frank. This comes from the website of the House Financial Services Committee. And, you know, it seems to me it's self-explanatory. We have the report card, at least from the view of the Congressional Committee, the majority of the Congressional Committee, about Dodd-Frank. And unfortunately, we have a discredited SEC. And I've been following and writing about the SEC for many years now, and I hope there will come a day when I do not have to refer to Bernie Madoff, but unfortunately we are not there yet, and Madoff certainly lingers on as a stain on the reputation of this agency. And Congress is not letting the SEC forget about it. So SEC Chairwoman Mary Shapiro regularly is called to Capitol Hill for oversight hearings. The SEC budget is the subject of intense scrutiny by Congress. The SEC is seeking an 18.5% increase over its 2012 budget, largely to implement Dodd-Frank. And I want to make clear, the SEC's budget has no impact on the federal deficit because it's all paid for by the industry. Representatives in Congress, however, cite the agency's failures and ask why they should give it more money. So cost-benefit analysis has become the rallying cry for those pursuing a deregulatory agenda. And, you know, we can all make this argument, and there may be truth in the argument. But the argument goes, regulations are too costly to comply with and harm the marketplace. They are a drag on business, and they impede job growth. So what we see is cost-benefit analysis is an argument that has traction and is seriously impeding SEC efforts to implement Dodd-Frank. And for my example for this, I'm going to talk about an issue that Professor Frankel talked about earlier, and that's harmonizing standards of conduct for broker-dealers and investment advisors who provide individualized investment advice to retail investors. And I've written several papers about this, and I'm not going to really go too much into the issue. And Professor Frankel did a good job of outlining the issue in broad scope. So broker-dealers traditionally are viewed as salespersons. They're subject to the FINRA suitability standard. If they make a recommendation, it must be suitable for the customer. Investment advisors are regulated by the Investment Advisors Act of 1940. The Supreme Court has held that they are fiduciaries, and they are held to a best interest standard to represent, to make decisions that are in the best interests of their customers. Now, so those nice categories, have fallen apart because, in fact, broker-dealers and investment advisors both give advice to their customers or clients, and they compete for business on the basis of their ability to give advice. So a 2008 RAND study found that there was investor confusion about the different labels, the different standards, but the RAND study also found that overall customers seem to be pretty happy with the quality of the advice they got. Nevertheless, there has been, I think, for some time, a general recognition that it doesn't make sense to have two different standards for professionals who are doing the same thing, and the goal would be to have high standards of conduct for financial services professionals in order to enhance investor protection. Investment advisors assert that investors are better off, are better protected by a best interest standard, that it's a higher standard than the broker-dealer suitability standard. Broker-dealers, needless to say, dispute that. I'm not going to go here into the arguments on that position, except to say that we don't really have a lot of empirical evidence about what standard protects investors better. All right, so Dodd-Frank, Section 913. Dodd-Frank required the SEC to conduct a 6-month study to evaluate the existing standards and whether or not there were gaps, shortcomings, or duplications in those standards. And the SEC actually completed that study on time, unlike some of the studies we've heard about today. After the study was completed, the SEC is authorized, but is not required, but it is authorized to establish standards of conduct for broker-dealers that is the same as that for investment advisors, except with some pretty big exceptions. No, the broker-dealer will not have any continuing duties to monitor or provide oversight over the customer's account. Brokers can sell only proprietary products, and conflicts are dealt with through disclosure and consent. So we hear it spoken about as a uniform fiduciary duty standard, but nobody really thinks that's what it is, or will be, or can be because of the statute. All right, so as I said, the SEC completed its study on time, January 2011, and recommended a uniform fiduciary standard with the qualifications I mentioned a moment ago. But the two Republican commissioners on the SEC at the time objected to the, it was an SEC staff study. I should make that clear. It was done by the staff, and it was released publicly, but it's not a position of the agency. However, as I said, the two Republican commissioners objected to the release of the study to the public at that time, thought it was premature because they said the study lacked a basis for concluding that a uniform standard would enhance investor protection, and they called for empirical data on the question. In other words, their point was, well, all right, the RAND study shows us there's investor confusion. The RAND study doesn't tell us that investors are being harmed. All right, but the study was released about, over a year ago. And after the release of the study, there was momentum building towards the SEC's release of a proposed rule, which of course would then trigger the rulemaking process. Industry groups on both sides were filing comment papers with the SEC. And as I said, there was an expectation encouraged by the commission that there would soon be a proposed rule. All right, then we get to July. Business Roundtable versus SEC, as has been mentioned earlier in this decision, the DC Circuit issued a really, really harsh, critical opinion of the agency, vacated the proxy access rule for failure to consider the rule's effect on efficiency, competition, and capital formation. And I'm quoting here some language from the opinion. The agency inconsistently and opportunistically framed the costs and benefits. They failed adequately to quantify the costs, and they failed to support their predictive judgments. Now, in my paper, I set forth an extensive analysis of the opinion. I'm not going to go through that. We really don't have time to go through that. Here, I'll tell you my bottom line. My bottom line is, if you look fairly at the SEC's rulemaking process, you see an agency that has expertise in this area, that has been considering this question of proxy access pretty consistently since about 2003, and you see them undertaking a deliberative rulemaking process. The rule was put out for comment. Numerous comment letters were filed. The SEC extended the comment period to allow additional comments on the comments that had been filed, and in particular sought comments on the empirical data that they had. The empirical evidence was inconclusive. The agency had to make predictions about the future behavior of directors and shareholders, about which reasonable minds can differ. One certainly wishes the agency had had better information. But if this constitutes arbitrary and capricious rulemaking process, which is the standard, it is unlikely that any future controversial rule is going to survive judicial review in the face of concerted opposition. And I might also mention the SEC spent over $2 million in staff time on this rule. So a lot of time, a lot of effort gone to waste. The SEC determined not to ask for a rehearing, determined not to file cert with the SEC. Ms. Shapiro has said proxy access is not dead, but we haven't seen anything further on the subject. So aftermath. All right, well, here is Mary Shapiro. Aftermath. So before a Senate committee, Ms. Shapiro earnestly offered assurances that we are, I'm quoting now, we are keenly aware that our rules have both costs and benefits, and that steps we take to protect the investing public also impact financial markets and industry participants who must comply with our rules. By the end of 2010, it was clear that the timetable for a uniform fiduciary standard rulemaking had been pushed back. In a January 2012 letter, Ms. Shapiro stated that the agency intended to issue a public request for information pertaining to retail financial advice and regulatory alternatives because much of the relevant economic data may not be publicly available. And some members of Congress have expressed their impatience with this. All right, so I think cost-benefit analysis is real, it's with us, and it is slowing down implementation of Dodd-Frank. I am not here to praise cost-benefit analysis. I'm not here to bury it. It's just there. It's just there. The GAO has described it as a useful tool, which it certainly is. A CFTC commissioner has described cost-benefit analysis as the sword of Damocles that is hanging over the heads of independent agencies who are now, according to this commissioner, experiencing paralysis about moving forward on rulemaking. I might also mention, I think I mentioned this earlier today, the CFTC, one of its final rules under Dodd-Frank is now before the DC District Court, charging it did not engage in adequate cost-benefit analysis. The committee, a very influential committee chaired by Professor Hal Scott at Harvard, the Committee on Capital Markets Regulation, has expressed deep concern about the inadequacy of cost-benefit analysis, and Congress has proposed a bill. It's still a proposed bill. It's the SEC Regulatory Accountability Act. I set it out on page 45 of your handout if you want to take a look at it. It's proposed legislation that would impose additional requirements on SEC rulemaking. This is a proposed rule that focuses specifically on the SEC. And not only cost-benefit analysis with respect to SEC rules, but also with respect to SEC orders. It sets forth 11 specific standards that the SEC should employ in engaging in cost-benefit analysis. In testimony before the House Committee on Financial Services, Ms. Shapiro expressed concern that enumeration of these factors would create a new potential challenge to future rules. In addition, she stated the rules requirements would be more extensive and more onerous than the requirements placed on other agencies. So that's where we are now. Again, you know, I'm certainly not here to argue that cost-benefit analysis is not important and necessary. But I am concerned about what we see, going back specifically to the uniform fiduciary standard that I was referring to. The brokerage industry got a lot of breaks in the legislation, such that it would never be, as I said, it would never be a truly fiduciary standard. So they got some, and you know, that's what the legislative process is about, right? So they did some successful talking on the Hill, and they got a legislation that is really pretty, that they can live with, I think. They have an entire rulemaking process that they can go through, and SIFMA certainly knows how to do this, and as I said before, the DC Circuit opinion, they were all cranked up to do that. So there would certainly have been an extensive rulemaking process. And it certainly, if they didn't like the outcome, if someone out there, whoever it is, whatever, if somebody out there didn't like the outcome, we would have a challenge in the DC courts about cost-benefit analysis. And it just really seems like there's just so many bites at this apple and so many ways that implementation can be delayed, and I find it very troublesome. So I think I'll stop there, and I'm out of time, so it's probably a good thing that I do. Let's see.
Okay, good afternoon, everybody. I'm I think I'm the one who takes the award for the longest title. I'm not sure we were giving awards today, but I looked at this earlier this morning and I thought, boy, that's a long title. And actually I was reminded that when my husband picked up the brochure, he said, that's really a long title and it's very complex. And my response to him was, so is the Dodd-Frank Act. So I think maybe it's just appropriate for that reason, if for nothing else. I want to focus on a different aspect of this equation of SEC reform. Barbara's remarks were really more on the substantive regulatory reforms that the SEC is engaging in. But I've done some work, and our work sort of talks to each other, I think, in many respects. I've done some work on the institutional reform at the SEC, so I'd like to spend my few minutes of fame with you today focusing on that. The two prior works that I am sort of extending through this invitation that Barbara graciously extended to me are two pieces of work that the abstracts are in your materials that represent the use of something called change management leadership, which is or change leadership literature, which is part of the management literature in the business area, not business law area, but the business area. And what I've done essentially in these two pieces is to take what was originally the SEC's own reform efforts well before Dodd-Frank, at the very beginning of the Obama administration, that it was undertaking on its own to reform itself. Why? Well, Barbara mentioned to you Bernie Madoff, and she mentioned to you financial crisis, and SEC being blamed for some of the deregulation that led in that direction. So President Obama, when he appointed Chairman Shapiro, said you need to change this agency. You need to shape this agency up. And among the things that she did was to engage in a lot of reforms, restructuring actually the internal operations of the SEC, including appointing Robert Kazami for the Enforcement Division, and he completely restructured that. And so these two pieces reflect on that. The second piece actually was already underway, and Dodd-Frank was just about to be adopted at the time the first piece came out. So Dodd-Frank was adopted in the interim, and I was able to make some preliminary reflections using the same literature on Dodd-Frank and where that was going. So the work that you're going to hear about today and my paper on this will extend my work in that area. So what are we talking about here? Dodd-Frank Section 967A1. Now, I'm well aware this is relatively small type, but essentially what you'll see here is that the SEC was charged in Dodd-Frank, among these many studies, the 67 that you've heard about, to go out and hire a third-party consultant to do a study on reforming itself. And there were certain criteria that had to be met, according to the law here, for the consultant that was being hired. And there also were certain things that Congress set out that needed to be studied in connection with the reform of the SEC. The provision in the Act goes on to actually outline specific baseline required areas of study and says that they're non-exclusive. The list includes these 6 bullet-pointed items that you see on the slide, basically looking again at the internal structure. Now keep in mind, this is already reform that was underway, but are there unnecessary units? Are there redundant units in the SEC? How do we improve communications so that one area is talking to the other, since the areas of regulation that the SEC engages in are not fully distinct? What's the command structure? Who goes to whom for what, and who rules whom on what? The effects of technology advancements. This has been, for those of you who follow the SEC speeches, a very large part of what the SEC has worried about, is the way that technology affects trading and the way that technology affects their operations and their ability to regulate. And they were behind technologically, in case that's not evident to all of you. Also, just their internal policies, who they hire, what kind of experts they need, and what kind of experts they have was a large part of what Congress was worried about. And finally, of course, the SEC provides oversight to the self-regulatory organizations, and Congress wanted to ensure that that process was efficient and efficacious. So in addition to prescribing these baseline areas for study, there were 2 other things Congress did. They basically said, once you go out and hire this consultant, that consultant has 150 days from the time that that consultant has been appointed to issue a report to you, SEC, and to us, Congress. And then after that, SEC, you have to report on a 6-month basis, starting 6 months after the issuance of the report and extending out for 2 years from the issuance of the report, about how you're doing and what you're doing. So what's happened with this to date? The Boston Consulting Group was the external third-party consultant who was retained by the Securities and Exchange Commission to do this work, and it issued its report on time in March of 2011. It made 16 different recommendations that all had to do with what it termed to be optimizing initiatives. Now, what does that mean? Basically, the BCG report comes out and says exactly what a number of people have said today, including Barbara, which is the SEC is so severely underfunded to think about actually saying, here's what the SEC can do, is just too simplistic. We have to talk about what the SEC can do given its existing resource base. Or we have to talk about Congress, you actually fully funding this agency and allowing it to go forward and do what it really could do to reform itself. So the report is actually relatively straightforward on the fact that the SEC is completely underfunded, not just for the substantive regulatory reforms it's been asked to do, but also for its internal reforms under Dodd-Frank. The SEC then made its first report back in September, again, on time. And basically what it said is, we're working on it, okay? We've developed the necessary program management and oversight infrastructure. In other words, we've put into place the structures and the mechanics of what it is we're going to do. And here's what we're going to do with that. We're going to take each of your 16 recommendations, BCG, and we're going to actually design some appropriate approaches for those recommendations that have been selected for implementation through this process. Okay, so sounds good. We're putting a process into place, so that's 6 months out. You may have noticed we are now at the very end of March 2012, and I've been waiting. The next 6-month report has not come out, okay? So I'm hopeful that by the time the paper comes out, it does, because otherwise there's not as much that I can say that I would like to say on some of the things that I'm concerned about here. So what is my research question? I want to know, is this worth the paper it's written on? The SEC was already in the process of reforming itself and working within its research constraints. A lot of money was spent, I'm assuming, and a lot of time was spent by BCG. This is not a firm that is inexpensive to hire, okay? Putting together a plan that sort of says, SEC, keep doing what you're doing, and here are the 16 areas in which you want to do it, okay? And I'm exaggerating that a little, but I don't think too much. So really what I want to find out here is, dirty little word, does the cost-benefit analysis, Barbara, come out positive? Why? Because it's my money and it's your money that's being spent on this to some extent, right? Because the SEC is funding the central government, as Barbara pointed out, with its overages, okay? It could be reforming itself and helping us all in the market, and instead, what it's doing is trying to spend a lot of money reforming itself. I'm not saying the reform effort is bad. Reform is good, and as you'll see, I have actually some positive thoughts about reform efforts and how one engages in them. I'm just wondering whether Dodd-Frank is the right way to approach this, okay? There are some offsetting considerations here, and this is what leads to the many words in my title, okay? There was already desire to do this, okay? The desire came from the executive branch, and it filtered through the SEC, and I've spent a lot of time in connection with those first 2 papers that I've written reading Chairman Shapiro's stuff. Okay, I hate calling her chairman. I noticed, Barbara, you called her chairwoman, but you know the statute actually calls her a chairman. And there's not that much I can do about that. And she prefers chairman, Eric says, so, and he would know best. Or Mary. Or Mary, there you go. Don't know her well enough for that yet. Okay. Our chairman, Mary Shapiro, and also Robert Kazami have actually engaged in a lot of efforts that when I originally started writing the 2 papers that are the predecessor works for this paper, I was very pessimistic about what their efforts might be able to do. But at the end of the process, it really seemed like actually they sort of knew what they were doing. They were good, effective change leaders, and the type of system that they put into place to reform themselves actually was fairly right-headed and did not involve any congressional action, okay? So the desire was already there. Do we need the rule? Then is where my question comes from, right? But there is conservatism here, right? Agencies generally, and the SEC is among them, are sort of slow to change, okay? And although part of the reforms have gotten rid of some of the hierarchy in the Securities and Exchange Commission, there's a lot of bureaucracy, okay? And so maybe that is what sort of militates in favor of a more structured, congressionally oriented process, right? These are just my thoughts now, right? I'm not coming to conclusions. Underfunding, we've already talked about it. Congress uses the SEC as a cash cow, is my way of expressing it, and that's what's on the slide, okay? For those of us who work in state universities, some of you, and are in law schools, at Cincinnati, I'm sure it's true, as it is at Tennessee, we fund the university too, so I'm familiar with this problem, okay? And hopefully my dean is not watching this right now, or my provost, worse yet, okay. And then congressional meddling, okay? So you can tell I already have a pejorative sense of this. Congress is jumping into the middle of a process that, in my view, looked like it was working okay. So I'm saying here that Congress is actually, you know, potentially putting a halt on something that was good, especially because what we now know is this process was put into place. It was a reform program, and it was intended to be funded. That's what Dodd-Frank said. And the reality with the change in the congressional leadership and the change in the congressional composition was that that funding was not forthcoming, okay? Last but not least, and this has been mentioned before, another interesting sort of offsetting concern here is that if you go back and you look at all of the people who've cataloged the reform efforts that are set forth under Dodd-Frank, there are at least 16 and as many as 24, depending on how you count them, just SEC studies, SEC-involved studies out of the 67, okay? So what I'm talking about here is a microcosm of a much larger issue. All right, that said, how might I approach this? I started looking at this and said, how does a lawyer even think about this question? I've got this question, it's an honest question. How do I approach it? It was pretty clear to me that the legal literature was not going to help me out here, which often happens when I ask these questions. That's how I got led into the change leadership literature before. So I've identified two different strains of literature outside the law that I'm looking at here in political science and in business and social science that I think will help maybe unlock some doors for us. And I have a stack of books next to my working chair in my living room, which my husband prefers should be my office, but it's not, because I actually am a March Madness person, and so I'm watching basketball and reading at the same time during halftime and things like that. The first strain of the literature is basically the public sector, public organization reform literature, which is out of political science, but also engages some psychology and sociology and a little bit of human anthropology. And basically, at the heart of that are two things. This change leadership literature actually appears there too, interestingly. But perhaps more importantly, and new for me, is the new public management movement literature, which for those of you who followed this is actually sort of an ebb and flow in particular the federal government, but also in state governments, where we've at various points in time tried to engage management that looks very much like what you see in the for-profit sector, management by metrics, okay? Cost-benefit analyses, right? You look at basically each different unit of an agency as something that produces a product. That was a dirty word in Tamar's presentation this morning, okay, the word product, right? But the bottom line is that's the way that this particular literature looks at things, product-based units and segregating them, something the SEC, again, I think was already doing to some extent. And again, the accountability here is private sector-like. You get funded if you're doing a good job. You get funded if you actually need things and can prove that you need them. And that's the way it works. So we have this love-hate relationship, apparently, with new public management in our federal government. And as I said, it's been an ebb and flow. I won't bore you with the details here, given the limited time that we have, but I've set out here that there are various different authors to whom I will be looking in my paper to help expand out this context, which I consider to be a background context for what I'm doing. 4 models that are really objectives, and I think the one that the SEC effort fits into most is in search of excellence, looking to move itself back to something that is a good, publicly accountable investor protection and market integrity maintenance organization. And then there are strategies, and there is another set of authors who've come up with 4 different strategies. And what's happening here is there was an original strategy without the congressional involvement that was what is referred to in this literature as charismatic transformation. And what's happened now is with the congressional involvement, it's moved things along a continuum toward what's called forced evolution. We're going to twist your arm and make you do it, right? Or even maybe dictatorial transformation, where it's not like we're just telling you got to do it. We're telling you got to do it and how you got to do it, and controlling here the purse strings. So I think we're close to dictatorial transformation based on my reading of the literature. And then, as I said, the change management leadership comes in here too. But where I want to focus most of the time in my paper is actually on program evaluation, which for some of you who work in nonprofits out there, you may be familiar with this. It's basically a way of using a research-like technique to evaluate programs. So you do the same kinds of things you would normally do in academic research, but the output here is a very practical output, and basically tells you, are you headed in the right direction, and if you are, why, and if you're not, what you need to do to get there. So you do the same kinds of things you do in an academic paper. You set up a problem, a question, a hypothesis. You engage in a targeted literature review, and then you set up a study design. You gather data from the organization, and you perform an analysis. It looks like BCG engaged that process actually here, okay? But now we all should be engaging this process to look at BCG's work, to look at what happens afterward. So I have three main areas of focus as a result of that I want to apply this project evaluation, program evaluation literature to. First of all, again, this big question, my big question, was it necessary, and if it was, were the contents of the legislative mandate in Section 967 of Dodd-Frank good? I mean, was it necessary, and were the contents good? Second of all, how good was the study? So I'm going to take a look at the study and try and apply the literature to BCG's work and see if it did, within the constraints that it had, because it was dictated a particular project there, to see if it did a reasonably good job, if it engaged the points of this literature. And then last but not least, and this is what I'm waiting for the new report on, is to start looking at how the SEC and Congress are reacting to this. How are they responding? Is something positive happening here, or does it just look like the wheels of bureaucracy are churning and churning away with nothing happening? The idea here is, does this make the SEC better, or does it not? So what are my next steps? I'm actually using this to develop a rubric for assessing Section 967 under those three different focus areas using program evaluation. I want to apply the rubric to the three different areas. And then last but not least, I want to comment on this because, as I noted before, this is actually just a microcosm of a much larger issue with so many studies in Dodd-Frank, so many studies in Sarbanes-Oxley, and a lot of them in both acts hitting the SEC and potentially derailing it from the more important regulatory efforts that it's engaging in to try and help investors and protect markets. So where am I on this? Well, I'd like to say I'm cautiously optimistic, but I think I'm cautiously pessimistic. And I think this quote that I found in some of the literature as I have been reading it basically summarizes things. There's a great process, program evaluation, that we can use, and it looks like people are trying to use it, but it may not be fully accepted. That may be why Congress has intervened here, for example, on the SEC's process that was already started. The quality of the work may not be quite what we want it to be. Congress may find that all of the work that BCG and the SEC have done lack credibility and may not fund it and may not approve what it's doing anyway. And so, based on the foregoing, it may not have very much impact on the SEC's ability to better regulate than it had before Dodd-Frank was enacted. So that's my story, and I'm sticking with it.
No, I don't need it. Great. Well, I'm very glad to be here. Thank you to the Cincinnati College of Law for having me, but also a special thanks to Barbara, who kindly invited me here 2 years ago, back when I was a lonely academic. And I couldn't make it then, so I'm very glad for the opportunity to come here today, where I'm now just a lowly regulator. It's interesting because we've kind of gone through the life cycle of the crisis. This morning, in the very first panel, we had a lot of discussion about causes of the crisis, and then we sort of moved into responses and strategies, and now we're getting into more of the nuts and bolts of how do we make principle go into reality. And I'd like to do a bit of that in my role at the Securities and Exchange Commission, and to not only talk a bit and give you a picture as to how implementation is going, but also to make you aware of an aspect of implementation that I believe does not get very much attention, but for the reasons that I'll say is something that is very relevant. Now, for those of you who have heard SEC officials speak before, as you know, I must give the standard disclaimer that I am speaking today purely in my personal capacity. The views that I'm about to express do not reflect the views or do not necessarily represent the views of the Commission or its staff. So, with that said, so I really have two goals. First is an informational goal. I want to kind of provide you with some information as to what we're doing on implementation. But second is to make some observations. This is where I get to put my academic hat on and make some observations about why you should be caring about implementation. And I mean caring about implementation not in the sense of, are we implementing the rules faithfully in accordance with Dodd-Frank? Are the rules good policy or not? But implications as to external factors that may be affecting how rules are implemented. Now, in my role at the SEC, what I do is focus on international regulatory policy. In fact, that is my responsibility. I'm in charge of international regulatory policy for the Commission. And so my bias is very much focused on our external relations. But as I would argue, a big portion of Dodd-Frank, in fact, I would say the overwhelming majority of Dodd-Frank, actually have significant international implications. And so what happens outside the United States affects what happens inside the United States and vice versa. So if you think about Dodd-Frank, Davis Polk, the law firm based in New York, seems to have a monopoly on keeping this track record as to how Dodd-Frank is going. Davis Polk calculated that the SEC had about 95 new rules that it had to promulgate in order to fully carry out its responsibilities under Dodd-Frank. And 95 does not reflect also the additional work, things like responding to the BCG report or doing special studies to Congress and various other things. There are certain kind of creation of new offices they have to do and things like that. That's a lot of work. Now, across the Dodd-Frank statute, there are 90 different provisions. 14 of those areas are directly relevant to the Securities Exchange Commission. And so this should not be brand new knowledge to anybody, but ranging from things like asset-backed securities to auditing issues, corporate governance issues, credit ratings, enforcement matters, market oversight, and investment advisors, as some of these topics have been touched upon today. Now, as I said before, many of these provisions have strong international implications. Some are very direct. It was mentioned before, this notion of disclosure rules regarding conflict minerals, okay, or activities in the Congo. Again, this was something that Congress included in the Dodd-Frank Act. The SEC must promulgate rules, but of course, this is definitely a case of where the international side is the heart of the bill. There was a special study requested by Congress, Section 929Y of the Dodd-Frank Act, regarding the study on cross-border private rights of action. This was a study that was slipped in at the very last minute in response to the Morrison v. NAB decision that came down by the Supreme Court. The Volcker Rule has significant international issues. As you probably know, all of the agencies, this is a joint rule of many agencies, including the SEC, over 17,000 comment letters have been received regarding the Volcker Rule. Not all of those comment letters, but there's been many comment letters have been coming in from foreign governments, okay, about how the Volcker Rule will affect trading in government securities. They have come from European and other foreign banks regarding how this is going to affect their investment funds practices. And then finally, systemically important financial institutions. Now, taking a step back here, okay, what does this really mean? What is it, if you were in the shoes of the regulator, what is it that you have to worry about? Well, there are really 4 problems that you have to think about when you think about international implications. First is the question, who? If we're going to promulgate rules, who should we be cooperating with? If the general sense is that whatever we do in the United States will affect foreign markets, and since this was a global financial crisis, we know that there are financial regulatory reforms also happening abroad. How will those developments affect us? We have to identify who should we be talking to. Are there important jurisdictions that are more important than others? Are there certain regional groups that are more important than maybe certain national groups? So that's the first question. Second is the what. What should be the subject of cooperation? I see that there are really 3 different categories. One is the question of international standards. What are those standards that should be governing what the rules should say on a country-by-country basis? Second is the problem of supervision. The fact is we have cross-border entities, call them financial market infrastructure utilities, call them banks, call them cross-border broker-dealers, call them investment funds. The fact is we have many cross-border entities, and they have to be supervised. And we cannot supervise them by ourselves. We have to share supervisory responsibility with other jurisdictions. So that's something we need to cooperate on. And finally, reporting requirements. I think one lesson of the financial crisis is that information is king. We can talk about what the regulators should or should not have done, but the fact of the matter is, if you don't know what's happening, you can't do anything about it. If the market doesn't know what's happening, the market can't react. If investors don't know what's happening, investors can't protect themselves. So information is probably one of the most important things that we can try to create in any type of financial regulatory reform measure. So that must be a subject of cooperation. Can we standardize forms of reporting? Can we come up with things like legal entity identifiers so that everybody is reporting in the same information, in the same form, so it can be processed in the same way? A third question is how? Once we've agreed that we need to cooperate and to who we cooperate with, how do we cooperate? Well, if you're talking about inconsistent rules and regulations between jurisdictions, we need to think about what regulatory strategies we have in order to address those differences. Should we consider national treatment principles? Should we consider special registration categories? Should we consider special exemptions for entities that may be registered in other jurisdictions? In the case of overcoming the challenge of supervision, what are going to be the legal frameworks that will underpin the cooperative relationships we have with other supervisors? Are we looking at additional memoranda of understanding between jurisdictions? Should we create supervisory colleges? Should we actually enter into regional agreements? And finally, regarding this issue about the need for common reporting requirements, should we create new international administrative bodies? For example, in the case of international financial reporting standards, IFRS is the principles effectively promulgated by the IASB, the International Association of Accounting Standards Board, okay, sort of the international component of the FASB here in the United States that promulgates US GAAP. Maybe we need to encourage the creation of more of these entities. So these are some of the questions that we must face. And finally, the last question is why? Why do we care? I sort of kind of started jumping in with this question that we need to cooperate. Well, the reason why we must care is because we worry about certain effects if we do not cooperate. Regulatory arbitrage, the ability for cross-border actors to game the system, to game the differences between national regulation. And if they can game the system in a way that they can circumvent our regulatory requirements, we may still be facing the same risks that we faced in the last financial crisis. How about market access? It's very easy to say that one way we can protect our market is we close off our market. Is that desirable? Okay, many of us who have savings, whether we're saving for our children's education, we're saving for retirement, we're saving to buy a new house, chances are a certain portion of your personal portfolio is exposed to foreign securities. Okay? If you go to the large fund companies like Fidelity or Vanguard, you'll see increasingly more and more of the funds that they're offering have some type of international component, international value funds, global index funds, things of that nature. Limiting market access would deny you those opportunities. Likewise, foreign investment may have a harder time coming into the United States. How about market competitiveness? Well, we care about differences because we worry about financial services industry activity going to other locations. Now, maybe some people, after hearing today's conference, may say, hey, that's great. We should encourage that. But there are definitely members of Congress who realize that financial services represent jobs, they underpin certain communities, and that we don't want necessarily these activities to be going to foreign jurisdictions. How about resources? Okay? We've talked already about resource constraints at the SEC. Should we give the SEC responsibility for being the global policeman of the securities markets? Does the SEC have the capability? And if the SEC doesn't have the capability because of limited resources, how does it share that responsibility with other jurisdictions? And that may be driving some of our cooperative relationships. And finally, systemic risk concerns. In a global integrated financial market, the fact is that systemic risk can come from outside your jurisdiction. Okay? The recent financial crisis, you could argue, was a problem in the United States that really infected the rest of the world. But the next financial crisis could be collapse of a large Chinese bank, could be some failure happening in Europe, could be something happening in the Middle East. And the fact is that we don't have the correct tools in place and the right relationships in place. Those events could easily cause a major systemic risk event here in the United States. Okay, so that's the why. I want to give you a case study to kind of put all of these kind of high principles into reality. And my case study is the regulation of OTC derivatives. We heard already that OTC derivatives was one of the most probably contentious parts of the negotiation of the Dodd-Frank Act. Using notional value, which Elizabeth pointed out is probably not the best measurement of the value of the OTC derivatives market, but it sounds really good. The notional value of the global swaps market is $700 trillion. So whenever I want to impress my wife, I tell her I'm regulating a $700 trillion market. It doesn't always work. Okay, so this is a big market. Now, what have we tried to do? Well, the starting point is actually the G20. Back in 2009 in Pittsburgh, the G20 leaders agreed on 4 basic goals with respect to OTC derivatives. Okay, and each of these goals should be accomplished by the end of 2012. So here we are, we're at the end of March 2012, so we've got about 9 months to go. First, all standardized OTC derivatives contracts should be traded on exchanges or trading platforms. Second, all standardized OTC derivative contracts should be cleared through central counterparties or CCPs. Third, all OTC derivative contracts should be reported to trade repositories. And fourth, any OTC derivative contracts that are not centrally cleared should be subject to higher capital requirements. And sort of implied in those 4 goals is a 5th one, which is we want to encourage standardization of OTC derivative contracts. We want to get away from bespoke OTC derivative contracts into standardized contracts. And the way we can do that is by increasing margin and capital requirements on those people who use non-standardized products. Okay? So we can loosely say that there are 5 regulatory objectives. I would argue that if you were coming from Mars and you were sitting here in the audience and this is all you knew about financial regulatory reform was what you heard today, you would think, okay, so this is a problem about some entity called the CFTC and the SEC duking it out to talk about how they're going to regulate the markets. In reality, we're only part of the story. Okay? The SEC and the CFTC definitely have responsibility divided up between securities-based swaps, in the case of the SEC, and regular swap products. We're responsible for regulation of the swap markets here in the United States. But there's a lot happening outside the United States. Okay? Well, actually, yesterday in the European Union, the European Parliament just gave final approval for their main directive, the European Market Infrastructure Regulation. that would impose pan-European requirements on the clearing and reporting of OTC derivative contracts. They have a second piece of legislation, the Markets and Financial Instruments Regulation, that would impose new requirements on trading and transparency. The European Securities and Markets Authority is in the process of issuing technical standards by end 2012 that would make those clearing and reporting requirements a reality in the European Union. In Japan, Japan actually passed legislation or an amendment of legislation even before Dodd-Frank was passed here. We like to think that the US is the first one, but actually Japan was first. However, they haven't yet finished their regulations. So they've done their legislation, they haven't done their regulations, and their public on record is saying that they too will get their regulations finished by end 2012. Hong Kong just published a consultation paper. This is a paper that they submitted for public comment on their OTC derivatives regulatory reform efforts. Singapore, 2 months later, issued their consultation. Similar process, public consultation process. Canada, they have a problem with Canada is that they don't have a national securities regulator, they have provincial securities regulators. But these provincial securities regulators have been working together as a group, coming up with a series of short papers on different aspects of OTC derivatives regulation, okay? The fact is there's a lot going on outside the United States, okay? So, but that's only on a country-by-country basis. Is there anything else that's happening? Well, you've got to go also into the multilateral sphere as well. There's something called the Financial Stability Board, okay? The Financial Stability Board, which was actually a creation of the G20 from the old Financial Stability Forum, which was pretty much a brainchild of a young Tim Geithner and a young Mario Draghi when they were both lower-level officials back in the mid-90s, that now has become probably the preeminent international coordinating body on financial regulation. Now, the FSB has been charged by the G20 to oversee implementation of the G20 commitment, which has been articulated in that 2009 Pittsburgh Summit communique. And it does so through peer reviews, through monitoring, through direct pressure from this body. But in addition to the FSB, you have the international standard setting bodies. And there are 4 major ones with respect to OTC derivatives. There is the International Organization of Securities Commissions, IOSCO, headed up by David Wright, formerly of the European Commission, and Masa Kono of the Japanese Financial Services Agency. We have the Basel Committee on Banking Supervision, chaired by Stefan Ingves of the Swedish Central Bank. We have the Committee on Payment and Settlement Systems, chaired by Paul Tucker of the Bank of England. And we have the Committee on the Global Financial System, chaired by Bill Dudley, president of the New York Fed. In addition to these multilateral groups, we have a number of bilateral dialogues. Since mid-2011, SEC and CFT staff have been having weekly phone calls with the European Commission, the European Securities and Markets Authority, the Japanese Financial Services Agency, the Hong Kong Securities and Futures Commission, the Singapore Monetary Authority, and the Canadian Securities Administrators. Believe me, with the time zone changes, there's a lot of early mornings and late nights. Okay, so these are all the different groups we're working with. Who are the ones on the international level actually promulgating these standards? And I'm doing this not, just to impress you as to you're getting your money's worth by what we're doing, but really to get across this notion of it's an incredibly complex structure that we've been working on in the international sphere, and there are many, many individuals involved in this process. So if we go through the alphabet soup of all the different groups which the SEC is involved in, they include the OTC Derivatives Regulators Forum, or ODRF, the OTC Derivatives Supervisors Group, or ODSG, the FSB OTC Derivatives Working Group, or ODWG, the FSB Standing Committee on Standards Implementation, SCSI, or we call it SCSI, the IOSCO, the more polite people call it SCSI, we call it SCSI, the IOSCO Task Force on OTC Derivatives, CPSS IOSCO on financial market infrastructures, okay? These are groups that meet in locales around the world, probably on They have phone calls probably every 3 weeks. They probably have in-person meetings about once every 2 months, okay? So when you talk about resource constraints, it gives you an idea of just in terms of personnel, just to keep up with everything that's going on, already you've taken away a pretty large group of people just to follow all the developments that's happening internationally. So how much more time do I have? 5 more minutes, okay, so I'll be quick. So what are these groups all working on? Okay, I already talked to you at a very high level. We want standard settings, we want supervisory cooperation. Well, more concretely, issues of concern include extraterritoriality. Okay, if you're going to regulate major international swap dealers, like your Goldmans, like your Deutsche Banks, they're very worried about having to comply with regulatory requirements in multiple jurisdictions. So a question that we're working on is how do we consider to what extent US rules will apply to cross-border transactions, working with our foreign counterparts to ensure that their rules don't apply to the same transactions, or if they do, would not result in a difficult situation where the entity cannot comply with both jurisdictions. Another concern, we've talked today a lot about banks. All right, something which people are now very concerned about is the safety and soundness of financial market infrastructures. One of the goals is central clearing of OTC derivative contracts. There are some who have argued that all you're doing is creating new systemically important institutions, in this case CCPs. So to that end, one of the projects that these international groups are working on is what we know of what is called the 4 safeguards for central clearing. So they broadly deal with oversight, that's safeguard number 1, access, that's safeguard number 2, dealing with member failure, CCP membership failure, that's number 3, and resolution of CCPs, that's number 4. And finally, a third issue that is of great international concern is if information is king, how do we deal with the sharing of information? What access to data can we guarantee regulators? Obviously, you have an interest in the data for entities that are based in your jurisdiction. But if risk may come from other jurisdictions, to what extent should you be able to get information about what's happening, let's say an American regulator, to figure out what's happening with an entity based in Japan or based in the European Union? Okay, and that's a question, okay? It's also known as the problem of plenary access, and it was actually the subject of congressional hearings just actually a couple weeks ago. So let me conclude by making some broad observations. Now I can put my academic hat back on. First, we must be aware of the fact that regulation is no longer a domestic activity. The international developments and issues that we agree upon in international fora directly inform what we do domestically. And you can imagine, okay, that there may be questions about our ability to make commitments in international fora that tie the hands of our domestic regulators. So for those of you who are administrative law scholars, this is something which I think is a new development or relatively recent development that will increasingly become more and more true as we really talk about regulating a global economy. Second is, with all these different layers, you got domestic rulemaking, you got international standard setting, you have international oversight like in groups like the FSB, you have bilateral discussions. You could imagine that if you are an interested party, and interested party I define broadly as agencies but also industry interests, you now have multiple places where you can try to relitigate issues. You have a domestic issue and you're not winning, take it to an international level. Take it to a foreign jurisdiction. Let the foreign jurisdiction raise the issue. There was an interesting New York Times article, I forget now, about a month ago. I don't know how true it is, but it was making the point that in order to defeat the Volcker rule, it was arguing that some banks were purposely going to foreign jurisdictions to raise certain issues in the hopes that foreign regulators would then try to bring up certain Volcker rule issues with their US counterparts. I mean, that's a clear example, if true, of trying to relitigate an issue in multiple fora. Third is the fact that we have different regulators also means we have different systems. The structure here in the United States, Elizabeth laid out that very complicated diagram. Obviously, that's not how other jurisdictions organize their regulators. The SEC is a market regulator, but often we are on the other side of a table with a bank supervisor, because that is how the foreign jurisdiction regulates derivative products, maybe through a bank supervisory model. As we try to agree on common standards, common processes, et cetera, the fact is we're coming from the problem with different assumptions, with different regulatory strategies, with different levels of experience. And so the international sphere has really forced a melding of market regulation versus prudential supervision, which is an interesting issue, and one that I think it's going to take some time to really resolve. Fourth, you're going to see increasingly formalization of international standards. I know some academics talk about something like soft law and the idea that we can just have non-binding agreements and everyone just kind of gets along and that's good enough. I think that as you start getting into deeper and more important issues that are more germane to local jurisdictions, you know, for example, if I am a jurisdiction where my most important industry is finance, and the large banks in my jurisdiction are probably the most important economic actors in my jurisdiction, you bet I'm going to do what I can to protect those entities. And so soft law may not be strong enough to really deal with these issues on an international level. We may require harder legal instruments to come to agreement. And finally, something I've written about as an academic is, I think we're becoming more like Europe, okay? And I don't mean in the sense of fashion or, you know, whatever, but I mean in the sense of, if you look at the European Union over since the late 50s, when the European Economic Community first came about, has been about a process of developing a single market where you have both an economic and an administrative system to develop common standards. And increasingly, over time, as we start dealing with financial regulatory issues that are very important to multiple jurisdictions, many of the strategies that the European Union used internally are showing up again in multilateral fora. And that's something that we need to be aware of, we should be prepared to talk about, and we need to debate here in the United States as to whether or not we're comfortable with those approaches. So I'll stop there. Thank you very much.
All right. Let's now begin our Q&A session. And for the benefit of those people who are participating in this event through webcast, I do ask you to please speak up loudly. And Molly Skipper is going to pass along this microphone. And also, I would like to ask our panelists to whom the questions are directed to please repeat the question first, so that the people who are participating to the website, through the website can understand the question as well as hear your answers clearly. Thank you.
I wanted to know whether there were any attempts for cost benefit of exemptions and cost benefit of no regulation.
Who gets the question, I guess?
All right, the question was there any cost-benefit analysis done with respect to no regulation or no exemptions? And to the best of my knowledge, no.
The gentleman at the back.
Thanks. By the way, I've really liked the seminar. I thought it's been great. All the presenters have been really good. I'm just curious. This isn't my area of law. This isn't what I practice in. And I've heard, I think we can all agree that government is incredibly inefficient, huge bureaucracy. I think every presenter has pretty much proved that. Sorry, Mr. Penn, you were really good.
I don't agree with that.
Yeah, no, you were good at that. I guess my only question would be, I've heard all the arguments for regulation. What's the argument for deregulation? if there is one, if you guys could. I'm just curious. I mean, there must be a reason why some people advocate for deregulation.
I think it's a hard question to answer in this environment, and I really think it relates to Tamar's question too. You know, the market obviously is always an alternative to regulation. The problem that I think we have with the legislative function, and I'm not blaming a particular Congress, is that both with Sarbanes-Oxley and with the Dodd-Frank Act, there's been a public hue and cry for somebody to do something, okay, in response to what were perceived to be broad problems, either in the securities regulation, financial fraud when it comes to, and accounting fraud when it comes to Sarbanes-Oxley, or separate and apart from that, the financial failures in the financial crisis in 2007, 2008, and beyond. And so, you know, we as academics, I think, oftentimes, you know, try and ask the question, you know, what would it be like if we just allowed the market to deal with this? And you've heard some people say today the market failed in a number of respects in checking things. And Congress, I think, was reacting to the perception of that without, you know, to the point of Tamar's question, actually individually in each of these areas looking at whether or not the market might be able to regulate. And I think somebody else also raised earlier, the combination of everything that's in the Dodd-Frank Act, we have no idea what that cocktail is going to do. There are things that could work against each other that might individually be laudatory in terms of their purpose and their effect. And yet you don't see people putting sunset provisions, for example, on these things, or having a regularized mechanic for studying empirically what happens when you do X, Y, and Z in the marketplace. And they move too fast. I mean, my view, they move too fast on all of this. There could be areas where maybe not deregulation, but no regulation would have been appropriate, or changes to the structure of various regulatory things that were already in place might have worked. I think you're asking a very complicated question. I don't know if the other panelists have any other thoughts.
I guess the reason I ask is it just seems like the more regulation there is, the more inefficiency there is too at the same time. It's just not mainstream. It seems like it. I remember one of the first speakers came up and they had a huge graph, and it was, you know, these are all the different agencies. These are all the different.
Yeah, that was Elizabeth. Yeah.
You know, it was very good. It's just amazing to me that so many agencies regulate so many different ones partially, other ones fully. It just doesn't seem efficient.
Well, you know, I think, well, yes, I think that's right. And what we have in Dodd-Frank, I mean, just elaborating, I guess, a little bit on what Joan is saying, you know, we know what the legislative model has been for financial regulation. It's been you create agencies, you delegate authority to agencies with expertise, and they're supposed to deal with the problem. We see Dodd-Frank is on steroids as far as that goes, as we've said, you know, up to 400 rulemakings required under tight deadlines without. So Congress is delegating and requiring a lot of action without a clear understanding of what went wrong and why it went wrong. We're still seeking answers to those very basic questions. And in an era where we now have, you know, economic difficulties, job displacements, and the concern that regulation is costly. There's no getting around that fact. So working out, you know, people, you can say Dodd-Frank was overreaching and now they're cutting back. You can say Dodd-Frank didn't go far enough and it's all the fault of the industry, and now the industry is getting even more, you know, you can play that any way you want, and you know, and there's no, who knows? You know, there's probably some validity in all those arguments, but it is just very complex.
I have a question, but first I wanted to, I know I'm not on this panel, respond to that previous question a bit, which is some historical context. I think if you start the clock right now and look where we are, the message would be, geez, what is Congress doing, or what are the regulators doing? Why is this complicated, and why is it not working? At least that seems to be the message you're hearing. But if you step back and look historically, the thing that's very helpful is the Congressional Oversight Panel that used to be run by Elizabeth Warren, put out a report in January of 2009. And its basic premise is, for about 50 years, from the 30s onward, we didn't have any major financial panics or crises like this, and that when things change with financial innovation and also with deregulation of the S&Ls after they faced what we heard earlier, which was these very high interest rates under Volcker, that sort of set off these failures. And in response to those failures, you got this kind of tightening a little bit. We heard about FIRREA in 1991, then more deregulation. Then we have the Enron scandals. We have long-term capital management. And for a moment, you get this reaction of a little tightening, but then more deregulation. And so I think if you just look at this last period, you might say, what are they doing with the regulations? I think some would argue that we had it right, it worked for 50 years, but this idea that this notion that we're going to have a free market in banking when the banks actually have the protection of deposit insurance doesn't make any sense. In other words, you can't have both ways. So I think that's part of what the problem is. But my question goes to Eric, which is, I don't know if this is accurate, but I think I read in the paper yesterday that the EU perhaps just banned naked credit default swaps. Did I read that correctly, or is proposing to do that? And which brings me to this question, you're not hearing this question about harmonization that you're alluding to, and also the WTO issues. What happens when one jurisdiction decides to do something, they decide that might make the markets where they are safer? I've been hearing this threat that under the WTO, they simply can't do that. So I want to kind of, this is worse than the cost-benefit analysis. This is an international body, not elected by people here who could perhaps say, we can't make our market safer.
Right. Well, first of all, regarding naked credit default swaps, I'm unfamiliar with that development. I haven't heard it, but that doesn't mean that maybe it is the case, but I don't know right now. So regarding WTO, so Gretchen Morgensen of the New York Times had a column about this. It's been something that some foreign governments have stated, especially in the context of the Volcker Rule. I think it's questionable whether or not there really is concern. Couple things. First is financial services is covered under the General Agreement of Trade and Services, GATS. GATS has very specific schedules that were negotiated, and many areas that deal with issues like the cross-border issues of trading and certain financial services have been specifically excluded from GATS. So question number one is, do the WTO principles of MFN and national treatment really do apply? Second is, if they do, then there's also a carve-out for prudential measures. And given the fact that many of the rules that we are talking about, especially take, for example, the Volcker Rule, actually are being passed for prudential risk mitigation efforts, the argument would be that the prudential exemption in the WTO would actually apply in that case, and therefore we don't have necessarily a WTO principle problem. The prudential exemption has never been litigated before. No WTO panel, no NAFTA panel has ever arbitrated one of these cases, so of course we're just speculating right now. But I think on a plain reading of the agreements, both NAFTA and the WTO, we don't think that there's an issue.
Good job, by the way, guys. And could the problem maybe be more, I guess, systemic, even than I think Stephen before was kind of alluding to, the cronyism and the revolving door and regulatory capture. But could it be more systemic and maybe more of an elegant solution? And could it be monetary policy that's easy money where these financial conglomerates are really chasing yield, because I see this as the problem being risk, and they're chasing yield by offering these risky instruments, and might it be monetary policy and maybe even fiat money, and I know there's a long history with that, but it does seem like these barring the Great Depression, historically, these crises have, happened after, or since we've had fiat money.
So just if I can ask a question of clarification, are you arguing for looser money or tighter money?
Well, I guess there's two parts to that. One, a free market in monetary policy. So in other words, no monetary policy. The market sets the interest rate, or some type of standard, gold standard, or whatever it might be. I know that's a very broad question, and probably one more appropriate for a form of economists, but.
Well, I mean, I'll just, obviously I can't comment on U.S. monetary policy, but I would refer you to the lectures that Ben Bernanke just gave at GW this week, actually the past couple of weeks. He's giving 4 lectures where he goes through, I think one lecture was on the Great Depression, but if I read in the paper correctly, his most recent lecture is about the Fed response to the most recent crisis, and he sort of explains why the Fed took the steps they did, including quantitative easing, which is one of the things that one of the policies they pursued. My guess is that his lectures would give you Ben Bernanke's answer to your question.
Hey, excellent presentations. Going to the structure of the agency, the SEC, should the SEC combine with the CFTC? And then also on swaps, I had a question about end users, and if swaps are used for risk mitigating activity, why should they be required to be put on a central exchange? It drives up the cost and it prevents risk mitigation that way.
Do you want to do the swaps and I'll do the SEC?
Sure, I'll do very quickly on swaps. I think that's definitely an argument that we've heard. And it's still under consideration. Yes.
And I think your question about the SEC and the CFTC, so that's the million-dollar question, right? In fact, I mean, really, Elizabeth was raising this concern very early in the day. What should our regulatory system look like? That's just a small issue, right? It's maybe the easiest one. The original report that the Obama administration came out with said, yes, the two agencies should be combined, should work toward a combination, right? Not an immediate fusion, because there are lots of political issues, lots of personnel issues involved in that. But that those two agencies look the most alike in terms of what they're trying to do policy-wise. The theories underlying the markets are more similar. So if you sort of look at them that way, while there are some differences, a lot of the rules overlap in terms of the type of rulemaking. When I deal with the SEC, I think of disclosure regulation, fraud prevention, and some substantive regulation, as Tamar Frankel raised this morning, right? And I think the CFTC has a lot of similar themes going on, not the same, but similar themes. And of course, we've got this problem with credit default swaps and trying to figure out sort of where they end up. But really, is a security the same as a banking product or an insurance product? We were having a great dinner conversation about this last night, and with crowdfunding, which is another area I've written about, are those interests that are not debt or equity, that are crowd-funded securities, are they meant to be regulated by the SEC, or do they look more like charitable donations, so we should regulate them that way, or do they look more like gambling, so that we should, in fact, regulate them through gambling regulation? There's this continuum here, and I think, Elizabeth has ideas about that she was sharing with her little continuum with the rainbow design this morning. And so I think it's actually part of a larger question, but the two easier ones, at least in terms of the people who've spent a lot of time with it, are that the SEC and the CFTC could move toward a consolidation that might gain some efficiencies. But all I've done is read that report, so I'm reacting to that report.
Okay, we have time for just one more question.
With all this talk of the federal government taking over more regulatory functions under Dodd-Frank, there's one provision that I don't think anybody's mentioned. For investment advisors, Dodd-Frank raised the threshold for when an investment advisor can register with the SEC, which has resulted in enormous numbers of mid-sized investment advisors having to register with state regulatory authorities, which is really interesting, particularly dealing with California. But at the same time, there seems to be no move afoot to help investment advisors know how to deal with requests from abroad for people who are interested in using U.S. investment advisors. And there isn't even the SEC there, because you're talking to the states who presumably have no interest in, you know, people in England or whatever. So I've tried to do research and find out where the regulation is, and I can't find it, but it's pretty hard to tell the client, hey, you know, go ahead and do what you want. And with the internet, at least with English-speaking countries, it's almost as if the people in England and Australia are here. It's not like it's far away. They're just a click away. So I wondered whether you had any insight into that.
Well, so I'll take a stab at it. So I think there's 2 points I'd like to draw from it. One is this question about why did we shift certain responsibility from, you know, a federal agency down to the state agencies, or why we divide between the CFTC and the SEC. You know, and a lot of it has to do with, you know, the political process's view about what is the capacity of an agency to do its job, to what degree do we want to give the agency that much power or responsibility, and things of that nature. And I think, you know, I have to go back and look at the debate during Dodd-Frank, but my guess is that may have been one of the reasons why they felt, look, the SEC just really can't oversee everybody, so we're going to kind of raise the threshold and push it down onto the states. On the issue of what do you do as an investment advisor who is not registered with the SEC, and you're receiving inquiries from foreign counterparts, you know, I can't speak as to the wisdom of whether or not we should require registration, but what I can say is that, you know, if we're worried about fraud, if we're worried about, which really is one of the major concerns about investment advisors, you know, from a regulator's point of view, what is the risk that we're worried about? You know, so what's the potential harm if a U.S.-based investment advisor accepts money from, let's say, a person in the UK? You know, normally we worry about the client suffering more than the investment advisor. So arguably the investment advisor still is subject to state regulation, or if they're larger, federal regulation, and would have to still abide by all the standard business conduct rules and record-keeping rules. But second, let's say that there is a harm, hypothetically, that is coming from a foreign jurisdiction that's going to affect the investment advisor. What I can tell you is that we have very good relations on an enforcement basis with jurisdictions like the UK. And one of the things that my office does is handle those enforcement requests. And there's always, you know, basic anti-fraud provisions that are still always lurking there. They're very powerful. Some foreign jurisdictions would say they're too powerful, but the U.S. anti-fraud provisions are very powerful and would probably apply in those type of situations, and that there would be a way for those activities to be prosecuted.
All right, now let's conclude our panel discussions, and we want to thank our panelists for sharing with us their insights on numerous important issues.